Right to education. Children in the U.S. have the right to an education. This right is ensured in many states' constitutions. Further defined by court decisions and now interpreted to mean that each child has the equal opportunity to pursue an education. Citizenship alone does not guarantee a free education. Statutes that establish public schools also generally establish how operating costs will be met. Being a resident does not mean that the student, parent, guardian must pay real estate tax. It means that the student must live in the school district in which he or she wants to attend. Being a resident, then, is a prerequisite to the right to a free public education within a specific school district. Alien and homeless children. In 1982, the U.S. Supreme Court ruled in Pyler v. Doe that the children of illegal aliens have had a right to a free public education, although today some continue to question this right, that the courts have been consistent in holding the Equal Protection Clause applies to all. Courts considered the implication on society of failure to educate all students. In 1987, the passage of the Stuart B. McKinley Homeless Assistance Act, which required that each state educational agency shall ensure that each child of a homeless individual and each homeless youth has access to a free, appropriate public education, and was amended in 1990 to require each school district to provide services to a homeless that are comparable to the services offered to other students in the school. The U.S. Supreme Court has affirmed that the students may sue school board members who are guilty of intentionally depriving students of their constitutional rights. The court held that school officials who discipline students unfairly cannot defend themselves against civil rights suits by claiming ignorance of pupils' basic constitutional rights in Wood v. Strickland in 1975. Due process is guaranteed by the 14th Amendment. The Equal Protection Clause states, "Nor shall any state deny to any person within its jurisdiction the equal protection of its law." Schools functioned under the doctrine loco parentis, in the place of the parent. This doctrine meant that schools could exercise almost complete control over students because they were acting as the parent's substitute under the doctrine of in loco parentis. The courts have usually upheld the rules and regulations of local boards of education, particularly about pupil conduct. Courts have not supported rules that are unconstitutional, vague, and/or overboard. Courts have ruled in favor of students when students cannot be suspended without some kind of hearing, so if there is no hearing, the school is liable. Procedural due process cases usually involve alleged violations of the 14th Amendment, which provide the protections of specified privileges of citizens, including notice to the student, impartiality of hearing process, and the right of representation. Substantive due process frequently addresses questions of students' constitutional rights to free speech versus the school's authority to maintain order and specific education. In Tinker case of versus Des Moines Independent School District in 1969 was significant. It involved a school board attempting to keep students from wearing black armbands in protest against U.S. military activities in Vietnam. The court clearly designated that the decision does not concern aggressive, disruptive action or even a group demonstration. The decision did make it clear that whatever their age, students have the constitutional rights, and the decision had a widespread effect on the operations of schools in the U.S. A general principle seems to be that if the dress and grooming do not incite and cause disruptive behavior or pose a health or safety problem, the court ruling is likely in support of the student. In more than 300 cases, that it is the student that has won most of the cases that is dealing with hairstyle. The courts have usually refused to uphold dress and hair length regulations for athletic teams or extracurricular groups unless the school proves that the hair or dress interfered with the student's ability to play the sport or perform the extracurricular activity. Corporal punishment. The opinion established that many states may constitutionalize or authorize corporal punishment without prior hearing or notice and without consent by the student's parents, or may, as the matter of the policy, elect to prohibit or limit the use of corporal punishment. Courts have also upheld that corporal punishment is not a violation of the Eighth Amendment, in which prohibits cruel and unusual punishments. In response to the greater sensitivity to student rights, many school districts have adopted administrative rules and regulations to restrict the occasion, nature, and manner of administering corporal punishment. Some say it can only be done by the principal or in the presence of another adult. In 1970, Congress removed sexual discrimination against students and employees in federally assisted programs. An individual or organization can allege that any policy or practice is discriminatory by writing a letter of complaint to the Secretary of Education. Marriage and pregnancy. Until the last 10 to 20 years, it was not unusual for school officials to expel students who were married. They believed that the women were to establish the household and therefore married students could not perform well in school. They also believed that exclusion would help deter other teenagers from being married. School officials today cannot prohibit a student from attending school merely because she or he is married. Married students have the same rights and privileges as unmarried students. Students' attendance and participation rights can be removed if he or she's behavior is detrimental to other students. Title IX prohibits the exclusion from school and from participation in extracurricular activities for pregnant students. Child abuse and neglect. Government bodies in the United States have the right to access police power, which means that the government is entrusted with the responsibility of looking after the health, safety, and welfare of all of its citizens, which means that the state and the state workers look after its own people of the state. This guardianship extends to the care for children who have been either abused or neglected by their parents. In most states, there are consequences when you do not mandatory report and are found guilty. Student publications. In 1970, Scoville v. Board of Education, students were expelled for distributing a newspaper called The Grass High. Students made it at home and criticized school officials and used vulgar language. Students were expelled under Illinois statute that empowered boards of education to expel pupils guilty of gross disobedience and misconduct. The Court of Appeals reversed the decision. The school board was not able to validate the students' disruption and interference as required by Tinker decision. The expelled students were entitled to collective damages. An implication is that the rights of the students regarding newspapers they print at home are stronger than the rights of free expression in official school publications. In 1988, the U.S. Supreme Court ruled that administrators have broad authority to control student expression in school, official newspapers, theater productions, and other forms that are part of the curriculum. In the Hazelwood School District, the principal deleted 2 pages of the spectrum rather than deleting the 3 offending articles required that they be modified. He stated that there was no time to make any changes in the articles and that the newspaper had to be printed immediately or not at all. 3 student journalists sued and contended that their freedom of speech had been violated. The U.S. Supreme Court upheld the principal's actions. In 1970s, the court decisions established the position that students with disabilities were entitled to an appropriate education. Public Law 94-142 that requires public school officials to keep disruptive and violent students with disabilities in their current classrooms pending hearings on their behavior. This act allows officials to suspend dangerous children with disabilities for a maximum of 10 days. Longer suspensions are permissible only if the child's parents consent. Student locker searches. The rationale is that school authorities are obligated to maintain discipline in a sound educational environment, and that the responsibility along with in-local police power give them the right to conduct searches and seizures of contraband on reasonable suspicion without a warrant. First, school officials may only search for evidence that a student has violated a school rule or law, and there must be a valid rule or law in place. Schools do not need a warrant to search a student's locker or vehicle. On campus, for searches of students' persons, however, courts apply a higher standard. Where reasonable suspicion exists, a school official's action will likely be upheld. Reasonable suspicion exists only when one has information that a student is in possession of something harmful or dangerous, or where there is evidence of illegal activity such as drug dealing. The way searches of students' persons are conducted. School officials are advised to have students remove content from their clothes rather than having a teacher or administrator do it. And further caution is not to force students to remove all their clothes or undress to their underwear. Title IX prohibits sexual discrimination, which includes harassment of other students, teasing and snapping bra straps, requesting sexual favors, making lewd comments about one's appearance or body parts, telling sexual jokes, engaging in physical abuse, and touching inappropriately. Teachers are to make it clear that sexual harassment will not be tolerated in schools. The U.S. Department of Education has said transgender students are protected from discrimination by federal law. They should use the bathroom of their gender identity at local level. Different statutes have been made. Cyberbullying. The Center for Disease Control and Prevention has identified 3 elements to cyberbullying: 1, unwanted aggressive behavior; 2, involving and perceived power imbalance; and 3, repeated multiple times or are likely to be repeated.